Hi everyone, it's Evan Brown, your favorite technology and intellectual property attorney. In a couple of recent videos, we have talked about work made for hire generally, and we've covered how it is defined. In this video, let's talk about a particular provision that should be in most independent contractor agreements because of the work made for hire doctrine. Remember that an employer owns the work that an employee creates within the scope of his or her employment. And in an independent contractor agreement, certain kinds of works can be work made for hire if the contract says that they are. So this gives rise to a couple of different issues that should be of concern in independent contractor agreements because of the work made for hire doctrine. The first concern is that if an independent contractor agreement is silent on the question of intellectual property ownership, the independent contractor will continue to own the copyright in the deliverables. This has come as a big surprise and given much distress to a lot of hiring parties who've spent money for the services of an independent contractor only to learn that they didn't own the copyright in the materials that were delivered. The second thing to be concerned about is the situation where the contract says that the deliverables are to be a work made for hire, but they are not the sort of work that the Copyright Act defines as being able to be work made for hire. We covered this list in the second video. Software would, in most circumstances, probably fall into this category. If the contract just says that the software will be a work made for hire, it may not establish ownership in the hiring party. That's because it's not really a work made for hire when created by an independent contractor. So you will often see independent contractor agreements say two things on this point. First, you'll often see language that says that the deliverables will be considered a work made for hire. Then you often see language that says, to the extent that the deliverables cannot be considered a work made for hire, the contractor hereby assigns all right, title, and interest in and to the intellectual property in the deliverables to the hiring party. You may have seen this language in a contract and thought it was redundant or unnecessary, but it does indeed serve a good purpose. Well, I hope you have found this information about work made for hire to be interesting and useful. If you're watching this video on YouTube, be sure to subscribe to this channel and turn on notifications so that you know when there is new content. If you're watching it on LinkedIn or YouTube, be sure to like it. Leave a comment. Let me know that you enjoyed it. If there's anything in particular I can help you out with, just drop me a line or give me a call. Why don't you go over and read my blog at evan.law. I'll talk to you again next time with more information about law and technology.